I invite our first keynote speaker to the podium, the prosecutor of the International Criminal Court, Madam Fatou Bensouda.
The Lord Mayor, Honorable Minister, Madam Attorney General, dear friends and colleagues, ladies and gentlemen, allow me at the outset to express my sincere appreciation to David, the International Humanitarian Law Dialogues, which today we acknowledge its decade of contributions to the discipline, the City of Nuremberg, and the Memoriam Nuremberg trials for extending a gracious invitation to me to address you in this historic venue, Trial Courtroom 600 of the Nuremberg trials. It is indeed a privilege to address you today in the very same room where 70 years ago, for the first time, those who committed some modern history's most shocking atrocity crimes were held accountable before a court of law. That these men, in Robert Jackson's words, were put to the judgment of the law is one of the most significant tributes that power has ever paid to reason. In this picturesque city, which has seen the worst and the best that humanity has to offer, we started an important mission, and that is to ensure that during conflict, during war, the laws will no longer remain silent. Through the important and symbolic achievements of the Nuremberg trials, we in effect declared that war and violence, as simply politics by other means, is no longer acceptable, and it's no longer acceptable to our cultural ethos. A paradigm shift in thinking had crystallized. The seeds has been planted towards the realization of an international criminal justice system. To be sure, Nuremberg, together with its sister tribunal in Tokyo, was a watershed moment. The General Assembly of the newly created United Nations was quick to adopt the principles set out in the judgment of the International Military Tribunal and to request the International Law Commission to prepare a draft code of offenses against the peace and security of mankind. Upon adopting the Genocide Convention the following year, the Assembly further requested the Commission to study the desirability and possibility of establishing an international criminal court to try perpetrators of genocide and other international crimes. However, as we know, the world was not ready to transform such a landmark into a lasting institution. The dynamics of the Cold War and the bipolar system in which the world was divided produced mass crimes in Europe, Latin America, Asia, and Africa. The latter was still very much under the rule of colonialism and apartheid. The world's political landscape was not ready to allow that necessary leap forward for humanity. In the end, the world would wait for almost half a century after the Nuremberg and Tokyo and would witness again two genocides, first in the former Yugoslavia and then in Rwanda, before the Security Council decided to create the UN ad hoc tribunals of ICTY and ICTR, which James and I, and many others in this room today, had the privilege to serve, thus connecting again peace to international criminal justice. The sense of urgency that gripped the international community in the early 1990s was similarly reflected in the request of the General Assembly in 1993 for the International Law Commission to complete its work on the draft statute for a permanent international criminal court. The Commission presented its final draft in 1994, paving the way for the Rome negotiations. The arc of justice, which started during the modern era in Nuremberg, thus continued towards Rome. I believe we are yet to fully appreciate and measure the contribution of the Nuremberg and Tokyo trials, as well as of the ad hoc tribunals, to the international law and international criminal justice. Truth be told, it is these institutions that first developed the necessary principles and jurisprudence which has allowed for the prosecution of the most responsible perpetrators, including sitting members of government and powerful warlords. They also contributed towards the prevention of crimes in conflict-torn regions and helped re-establish the domestic rule of law, as revitalized and reformed national jurisdictions have increasingly shouldered the burden of investigating and prosecuting such crimes. In these and in so many other ways, the International Criminal Court is a direct result of the legacy of Nuremberg. Indeed, in Rome in 1998, the once unthinkable happened. More than 120 states, supported by the robust activism of civil society and victims groups, created an international criminal court. A permanent court with jurisdiction over genocide, crimes against humanity, and war crimes, and soon the crime of aggression, or crimes against peace, also a unique legacy of Nuremberg. On this latter crime, I would like to acknowledge, in particular, the pioneering and heroic work of our dear friends who are present here today, Christian Venovesa, Don Ferenc, and of course Ben, who, while not present here with us today, still inspires so many of us as we engage in this evolving discipline. International justice was not a moment in time any longer, neither an ad hoc solution dependent on the political will of the Security Council. It became a permanent institution with the capacity to act independently of the political machinations of the Council. The bricks had been laid for the creation of a global system based on the international rule of law. The goal was no longer the stuff of fantasies, but a work in progress. That work, dear friends, deserves to be supported in all four corners. Not for me, not for the court, but for the betterment and progress of humanity. Ladies and gentlemen, as prosecutor of the International Criminal Court since 2012, my objectives are to seek to hold perpetrators of the worst international crimes to account where I have jurisdiction. In turn, to bring a measure of justice to victims and affected communities, and to contribute to the deterrence of such crimes. I undertake this mandate with full determination and with complete independence and impartiality, and to be clear, without fear or favor. For those who closely follow the court's work, they would know that my office has never been busier. We are conducting multiple investigations and prosecutions in more than 20 cases, involving 39 alleged perpetrators across the 10 situations where we are operating. In addition to our investigations and prosecutions, my office is also conducting preliminary examinations in 9 different situations. Earlier today, I announced the opening of yet another preliminary examination, and this time concerning the Gabonese Republic, following a self-referral, another self-referral from Africa that we received just recently. The responsibilities placed on the court are great. In short, there is no room for error or deficiencies. Each case is complex, evidence is voluminous, the operational environment is fragile or even hostile, and leadership structures are often very difficult to penetrate. Our efforts have been geared towards continuously producing positive results in all our activities. We do this through a continuous process of self-assessment and a bona fide commitment to hone our practices to be as effective and as efficient as we can be. My deputy, James, and I have been unbending in this regard since we both assumed office in our respective roles. Moreover, my office continues to work on the promulgation of a number of policies that give clarity and guide the office's work in accordance with the Rome Statute. As you may know, based on a number of strategic priorities I set for the office, we adopted in December 2014 of a comprehensive policy paper on sexual and gender-based crimes. Since then, Jean-Pierre Bemba, the former Vice President of the Democratic Republic of Congo, was convicted earlier this year for largely the crime of rape committed by his troops in the Central African Republic. This conviction is a crucial landmark for my office and the court, and I hope for the cause of international criminal justice. We are also in the process of finalizing our policy on children in and affected by armed conflict, which will be officially launched at the Assembly of States Parties in November of this year. On the heels of the successful outcome of the Al-Mahdi case, where we charged the defendant with deliberate attacks against historic monuments and buildings dedicated to religion in Timbuktu, I have decided to focus our next policy paper on the protection of cultural property to further highlight the severity of these offenses and to hone our ability to investigate and prosecute these serious crimes. I would like to take a few moments to mention the recently promulgated policy paper on case selection and prioritization. One of the main goals of my tenure as prosecutor is to strengthen trust and respect for the office and its crucial mandate by ensuring further transparency and predictability in our operations. In short, the policy paper sets out the considerations which guide the exercise of prosecutorial discretion in the selection and prioritization of cases for investigation and prosecution. It provides a detailed description of the policy and the practice of my office in relation to the process of choosing the incidents, the person and conduct to be investigated and prosecuted within a given situation and across different situations. In addition to taking a positive view towards complementarity, a strategic goal of my office is to develop with partners a coordinated investigative and prosecutorial strategy to close the impunity gap in accordance with our respective independent mandates. And this also applies to other types of criminality which may constitute serious crimes under national law and that are often connected with ICC crimes, such as arms trafficking, human trafficking, terrorism, financial crimes, or the illegal exploitation of natural resources. After all, the arc of justice can only be complete when the various aspects of criminality are effectively addressed through effective cooperation of committed institutions, and the victims of all these crimes are able to seek redress. This last aspect brings directly on the legacy of Nuremberg trials, including the subsequent proceedings which sought to capture the true extent of responsibility across the various institutions and the sectors of society that contributed to the commission of such terrible crimes during World War II, such as the Flick, I.G. Farben, and Krupp trials against major industrialists of the time. We have long stated at the Office of the Prosecutor that we wish to pursue the true extent of criminality in the situations within our jurisdiction. If we are to truly reflect the drivers of conflict, this means also examining the economic drivers of conflict. We have far to go, still far to go in this regard, to build on the full legacy of the Nuremberg trials, but it is a path we are committed to follow. Ladies and gentlemen, 70 years after the Nuremberg trials, the arc of justice is filled with strong, consistent legal principles, instruments, and institutions. It has seen the development and the strengthening of impressive and far-reaching jurisprudence. It bends closer and closer towards ensuring the protection of citizens all over the world from mass atrocities. But one consistent need remains: the full and timely support of the international community through cooperation, diplomatic support, and the granting of the necessary resources to fully exercise its mandate. I would be amiss not to recognize here the important role that academia has played, or is playing, and can play in further analyzing and explaining the work that we do and the role and impact that the ICC has had inside this arc and beyond, just like the work of researching and commemorating the Nuremberg trials continues. On this day, we must all recommit to this same idea, this same goal, as 70 years ago: bring justice to victims of mass atrocities and to put an end to impunity. You can count on my absolute commitment, as well as that of my office, to continue on this path. In closing, allow me to observe that the fight against impunity, the ICC and the international criminal justice system it is aiming to create in its own image, will persevere and thrive. They will do so not because of hopeful aspirations of their supporters or faltering by their detractors, but because of what they stand for as powerful ideas, because they meet vital needs for humanity's progress in the modern era, because without them, we will regress into an even more turbulent world where chaos, volatility, and violence are seen as inevitable norms. And this humanity will not allow. We owe it to ourselves, our children, and to the future generations to nurture the ICC so that it carries on its crucial work to fight against impunity and to foster the Rome Statute system of international criminal justice. We must do all we can to ensure that security, stability, and the protective embrace of the law become a reality to be relished by all, in all corners of the world. Our responsibilities remain great, but our resolve must endure. On this path, humanity has come a long way indeed, but we have miles to go still before we sleep. I thank you.